Today I have learned 3 words in Kannada, Nannaduru Keli. I have also learned how to write Chandru in Kannada. Therefore, my Balapadam starts from today. And please forgive me for not speaking in Kannada, though the Kannada book is being released. I am happy that what I attempted 10 years before, after my retirement, all the retired judges, they speak or they write. Having nothing else to do, I started writing. I also thought, why not I write on the women who came to my court. So when I started cataloging those cases, all the women were different parts of life, coming from different social background, coming with different problem. But the underlying theme, the underlying song was they want to fight it out, never want to give up. Therefore, when I wrote the book, first in Tamil, I gave the title Sattattal Yuddham Sai, which means fight with the law in court. Therefore, Sattattal Yuddham Sai, women fight with law. That became, when it went to English, it became listen to my case. What I started, that women should fight with law as a weapon, now became a pleading, listen to my case. The listen to my case in court has now become a listen to my case to the audience in general, so that women will think that we have one more forum to fight, and that is how Nannaduru Keli is before you. In this book, though I have described several instances of women with different issues came to court and how the court dealt with those issues, I must tell you, after these cases were published, one women reporter of Bar and Bench, a web magazine, asked me, "Are you a feminist?" I don't know what to give an answer. I told him, if you call me a feminist, I'll be happy. And if you think my cases became the basis for that tag, I'll be doubly happy, because I am able to fight beyond the gender discrimination. I am able to render certain decisions, forgetting the misogyny that is surrounding in court and law. In that way, I'll be happy that if you call me as a feminist. Then another reporter followed this, asked me, how did you get these ideas? That the thinking in this fashion and not in any other fashion, because there are enough precedents in law for both sides. One thing about law is intended to make lawyers to make more money. They can keep on fighting. There are decisions on both sides, and therefore you can keep on referring to different decisions. But ultimately, if you are conscious, if you are having an orientation that this constitution is gender neutral, this constitution does not have a bias, then you have an orientation in one way. It is in that sense we were oriented towards to see matters beyond gender discrimination. Now, in my youth days, in my student days, I used to work with Mahila Front, All India Democratic Women's Association. I used to help them with their grievance cell, where they used to have a weekend advice to women. Number of women used to come with different problems. So it is our student days, it is our lawyer days, we were exposed to multifarious problems. So when we were made as a judge, we already knew what's happening in this world, and therefore where we stand, and we took a definite stand in these matters. When such matters came, whether lawyers argue or not, we have enough orientation to take the case further, and that is how these cases came to be rendered, decisions were rendered, and ultimately I have summarized some of them in this book, and I am sure this book will be of some assistance to you. when it comes to gender justice, I will not take much time because nothing much to speak about the book, but only on two cases which I have described in this book. The one case relates to whether a woman can become a priest. If a woman can be worshipped in the form of a goddess, in the form of a female form, why not she also perform puja? It's a very logical question. Now this case did not come to me in a direct form. It came in a very indirect form. There was a woman whose father was a pujari in a village temple, and she was performing whenever father was absent. She goes along with the father sometimes. When father was busy, she used to go. Nobody in the village objected her performing the puja in the temple. One day the father passed away, and as a dutiful daughter, she took up doing puja in the temple. Now the question came, her cousins, that is father, paternal uncle's sons, who are in the same village, they were waiting for an opportunity. As soon as the father went away, they told, how is this woman is doing all these rituals? She is not meant for this. After her father's death, as a reversioner, the right should come to us. That is father's, brother's, children. So they created a problem, and the village sabha was convened, the village panchayat. And as usual, all this panchayat, like the Kap panchayat or the caste panchayat, takes the misogynist route, and they all said that she should give up the right and only the cousins will perform the puja. This was purely a law and order problem, and the village got divided. The majority were with the cousin, a minority was with the woman. Then the Tahsildar came, not because of a religious issue, because of a law and order issue. As usual, you know, under the Criminal Procedure Code, if there is a law and order problem, the revenue officers come in. It was so unfortunate or fortunate, the women Tahsildar who came, she was a woman, but fortunately or unfortunately, she did not see either the constitution or the law. She convened the meeting, she saw the feelings of the majority, and in our country, the majority prevails, whether right or wrong. It is a majoritarian notion which takes precedence over the law, over justice, over gender justice. And therefore she, in a way, to get out of the problem, she told that lady, her name is Pinnayakal, she told Pinnayakal, you give that power to your cousins. If you think you have a right, you go to the court and establish your right. You know, under Article 26, if you have a religious right, if that part of a religious essential practice of religion or an integral part of religion, it is ultimately the court will have to decide whether such a right exists or not. Therefore, it becomes a civil right. So she wrote a very simple order that this lady will go to court, till then cousins will perform. This is something which is never contemplated under the Criminal Procedure Code, because in Criminal Procedure Code, to avoid law and order, if there are two groups, both groups are asked to stay away, and then the group which is already enjoying the right will be allowed to enjoy the right until the other group dislodges the right in the court of law. Therefore, what is called a status quo has to be maintained. But this Tahsildar, unfortunately women Tahsildar, changed the status quo because she went by the majority. She said cousins will perform puja and she will have to go to court. And Pinnayakal did not give up. She was a very ordinary woman, not formally educated. She came to court saying that this Tahsildar was wrong. This order passed under the Criminal Procedure Code was illegal. So what came before me was only a criminal law. A simple solution is available in records, namely maintain status quo, disputing party go to civil court. Very simple formula. This is how the British were doing. This is how post-British we were doing. But in this case, what was involved is the gender right. Therefore, the law got perverted, even by a woman. Most important thing is to learn that it is merely because of women you don't get a women's consciousness. Because you have been ruled, you have been made to believe that you are number two and not number one. You are a secondary citizen. And therefore, I asked that lawyer, how is this order valid? The lawyer went on arguing, no, essentially law and order. And then law and order is saved because majority is pleased. If that is accepted in this country, only majority will rule, minority will have to leave this country. As it is, people are saying, go to Pakistan. Therefore, we'll have to go there only. Therefore, I said, this is not the law. I told the Tahsildar, you made a mistake. First of all, you have not read Criminal Procedure Code. You have not read the judgments. Far up behind that, there is a constitutional duty, there is a constitutional mandate that women shall not be discriminated in any form. Under Article 15(1), there is a clear mandate that there shall not be a discrimination only on grounds of women. Now the question is, I did not want to leave it with a mere criminal solution. I want to go beyond. Is there a Shastra? Is there a holy book which says women cannot be a pujari? There is no Shastra, there is no ritual, no Vedas have said like that. On the contrary, in the olden days, women have learned Vedas. There are Veda scholars in the olden days. And there is no law which prohibits such a function. And therefore I said, if this sky is not falling, it is because we are holding the sky. To hold the sky, we need both of them to hold the sky. Not one cannot hold this weight, and therefore it is the women also hold the sky. And if you think the Constitution mandates, there is a constitutional duty that all obscurantic practices against women should be eschewed from our practice. If that is going to be there, in the absence of any injunction from Shastras, in the absence of any other legal bar, there can never be a prohibition. And I also added, if a woman can be worshipped in a female form, why not a female do the puja? It defies anybody's logic to say they can't come inside the temple. And I passed this order saying that this Pennayakal will be given the pujari right. If the cousins want, they can go to court. Finally, the cousins went to the court and lost the case. And now Pennayakal has to come to the village. And as I told you, the majority is against her. Now what do the state do when majority is against, but the law is in your favor? Then we send police protection. If there is a land dispute and there is a mob which denies the right and the landowner gets the title, we send the police, we send the armed guards to protect the orders of the court. That is how we execute court orders. It is the majesty of the court to enforce its orders. Therefore, I told the district collector, Madurai, go with the armed guards and then establish the right, give the key to the woman. And he went with the post of armed policemen, 100 policemen marched to the village and got the key and gave it to her. And Pennayakal performed the puja. This is how the law is established. This is how the judiciary becomes gender neutral. I won't say gender bias. We are gender neutral because we establish law. We interpret the Constitution. We interpret the Constitution the way it has been written, not the other way around. It is not Manuvadi. It is Ambedkar Constitution which provides. That should be kept in mind. And therefore, the law was provided. The next day when the judgment came, the Chief Minister of Tamil Nadu, Mr. Karunanidhi, announced in the full of the House that we welcome this judgment. We welcome all progressive judgments from court. It is because the Constitution under Article 26 which says that the Parliament can make law to reform the religious practices in the interest of public health, morality and public welfare. Therefore, even if the constitution authorities, even if the mandated legislature do not come in, it is the duty of the court to establish the rights of the parties. And in that duty, we must establish gender justice. This story you can read in the book, but a story which you cannot read in the book, let me come to that story, because that's a larger story. The larger story is in Sabarimala, women cannot worship. You can worship from home, but you can't go to Sabarimala. Why? That has been the practice. Why? That has been the belief. If you deeply further analyze the reasons, they say they can pollute. How will they pollute? No, we are not going to explain. From the age of 15 to 50, no women will be allowed. It's an injunction given by certain misogynists. Is there any Shastric injunction on this? Is there any text on this? Nobody knows. This is a practice. You must know under the constitution, all practices are not recognized as a religious practice. It should form part of the integral part of the religion. It should become the essential part of the religion. Who decides what is integral, what is essential? It is the judges who decide. In fact, there is a saying that it is not what is written in the constitution, it is what the judges say is the constitution. Therefore, judges do play. Judges do have a right to interpret the constitution. And if the judges are at faulty, what the court can do, the parliament can step in, can amend the constitution if they think the basis of the judgment was erroneous. It has been done so. This constitution has been amended, 108 times it has been amended. And therefore there is nothing new. We do not think that the constitution is a holy scripture. But if it does not serve the wishes of the people, if it does not serve the goal for which it has been drafted, we can always change the constitution. But what happened in this case was, some good Samaritans went to the Supreme Court, not any worshipper. Some young lawyers went to the court and asked the court, how is that in this country, after 70 years of independence, after 68 years of the constitution, how is that the women are prevented? There was a constitution bench of 5 judges, 4 male, 1 female judge, more important. Now 5 judges heard the matter for 20 days, finally gave a judgment that there is no bar in women going to the Sabarimala. If there is a bar, such a bar is an illegal bar. There is no sanction, religious or otherwise, preventing women from going and worshipping Lord Ayyappa. This is a judgment of a constitution bench. And curiously you will find all 4 male judges were majority, and the only female judge said women are polluting and this belief cannot be underlined and therefore women cannot go. This again brings back, just not being a woman is enough. You must be a conscious woman. You must be a woman with certain orientation. You must be a woman who is liberated from all old wrong ideas. In fact, last week, Madras High Court gave a ruling. It was presented by a lady judge. It was before a division bench. There was a divorce matter from her family court. The husband said, woman is cruel. How is she cruel? No, when she goes to bathroom, she removes the tali, Mangal Sutra. That removing Mangal Sutra itself is cruel. Written by a woman. That if I go to bathroom, or if I go to some other place, or if I have some rashes, or some itches, I can remove. Is there any religious belief that all times, in fact I know last month my niece went to the maternity ward. Doctor said remove that Mangal Sutra. She promptly removed. There is nothing wrong, because in X-ray, in the operation theatre, they don't allow all these things. These jewelleries they don't allow, and it was removed. How is that a lady judge writes removal of Mangala Sutra is a cruelty to man? In fact, Justice Mohandas mentioned about Periyar. Periyar was a social reformer. He is not only a rationalist, he is also a defender of women's rights. Somebody asked him, Sir, what do you say about tying Mangal Sutra? He said, that is a symbol of slavery. I will never allow a woman to wear a thali. But he also said, because he is a man who can argue brilliantly, he said, if that same rule is given to a man, I will also permit the woman to wear. Let man also wear a thali. Why would only a woman should carry that she is a married woman? Therefore, he said it's a slavery. And therefore, we find today that interpretation of constitution, interpretation of social issues is not only one way. It doesn't mean every judge interprets the same way. In fact, writing this Ayyappan temple judgment, Justice Chandrachud wrote that preventing women amounting to practicing untouchability, which is abolished under Article 17. Nobody ever thought on this line. That how do you prevent? On the basis of pollution? On the basis of pollution, if you prevent, it is Article 17 which talks about untouchability in all forms. Now this judgment has come 3 years ago. Some women wanted to go. They were beaten up and thrown out. Police is looking on the other side. Now where do you justify or implement a great constitutional right of women? In fact, last year I went to Kannur Law College. I saw from Kasargod to Kanyakumari, women were standing on the road. Mahila Matil, women wall. Never in the history of India, 670 kilometers, women were standing in the streets, allow us to go to the temple. They have not gone. What happened to the judgment? Under Article 152, 142, it is binding, it is enforceable. There are women wanting to go. No, we want to review the judgment. The case was heard by 5 judges. It should be heard by the same 5 judges, a review. But this case, review goes to a 9-judge bench. All right, constitute a 9-judge bench. We have no judges now. Wait for some time. So Ayyappan has to wait to see his own women devotees to come there, and their lordships will be busy going to London, going to New York, going to Moscow, giving lectures on gender neutrality, giving lectures on freedom of expression. You know, when Chandrachud, the same Chandrachud went to London, the students of London School of Economics said, how is that in your country there is so much hate politics going on? What will a sitting judge do? Some politician will say, no comments, or they'll go through the back door like Modi. Modi recently went to Germany. Suddenly he saw so many group of people. He didn't know their newsmen. When they asked a question, he could not give an answer at all. But Chandrachud was a little clever. He said, I am a sitting judge. Some of these cases are before me. I can't speak. All right, sir, at least speak in the court now. Where is the 9 judges now? Why would the devotees wait to see Lord Ayyappa when there is already a judgment which is not stayed by any court, which is a binding precedent on all governments? That is why I am saying, Pinnayakal may win, but many Pinnayakals will not come in this country because there is so much misogyny, there is so much gender bias that the interpretation of the constitution itself is a questionable form. It is not one day or 2 days. It has been a 75 years of wait for the women to see the true interpretation of the constitution. This is one example. If a judge who is little conscious can bring Pinnayakal, a judge who is little conscious can rule on Ayyappan temple issue. But a judge who is not having such consciousness, who is pandering to the majority notion, you will find Ram Janmabhoomi judgment. 1,000 paragraphs they have written. 7 judges have signed. Unanimous, they said. We asked the question, why is it anonymous? Who is the author of this judgment? Any title suit, as justice will say, you must have a parent document. You must have a title deed. This is the only judgment in India which says majority faith. Is the faith of 500 years is enough. Where are we going? This is the majoritarian notion which the Tahsildar was doing in Madurai village. This is the same majoritarian notion their lordships are sitting and doing in Supreme Court. Now this is the most dangerous situation, that the majority tries to bulldoze, the majority try to dictate what others should do, what others should wear, what others should eat, what others should follow, what others should speak, what others should elect as a leader. One nation, one leader, one religion. Very happy. That's not the constitution. This is not the constitution. This is your notion. Your Nagpur constitution. That is why I am saying India cannot be dictated from Nagpur. It has to be dictated from the people of India, who gave the constitution to ourselves. That is why Dr. Ambedkar very clearly said, there is no author, because the authors are 1.3 billion people of this country. They are the owners, they are the executors, and they are the judges. And therefore we appeal to the people that this kind of one notion, one dimensional theory must be restored. I'll come to my second example. There is a lady by name Kasturi. You read that book, you'll know. She is a clerk in the airport authority. She went to court. Her father was a Gandhian. He was wearing khadar all the time. So as a girl, she imbibed the father's trait. She started wearing khadar sari. One day the airport authority said, you must wear the uniform given by the airport authority. That is prepared in nylon sari. She said, I will never wear a nylon sari. No synthetic in my life. It is a hand-won own khadi sari I will wear. The reply to the action was, she was suspended from service. Not because of any misconduct. Only punishment was, only sin was, she married a khadar sari. Then she came to court. She didn't give up. After all, one wearing a nylon sari during working hours would have saved her. But she is Kasturi. She wanted to fight. Her case came before me. I asked the airport authority, have you read the constitution? I asked the managing director, have you ever read the constitution? We must remember the cherished ideas which brought freedom to this country. Fundamental duty. We must remember all the ideals. One of the ideals is, don't wear foreign clothes. Wear Swadeshi cloth. This is what Gandhi said. Once unwittingly, Pandit Jawaharlal Nehru said that khadi will continue as long as India becomes industrialist nation. There are many Gandhians who wrote to Gandhi who was in Varda Ashram. Babuji, Panditji says that khadar will continue only till India becomes industrial nation. Is that correct? Gandhiji was spinning cotton. He wrote back. In fact, he had the modesty to write to every person who writes a letter. Not like our Modi, who doesn't speak. He only says monkey bath. Many people in Tamil Nadu think his monkey bath means monkey is having a bath. Because he speaks only in Hindi. He doesn't know there are 22 other languages. Under Schedule 8, every language is an equal language. Why can't he speak? Why can't he have a translation? He doesn't have. Even if he goes to foreign country, he speaks in Hindi, so that nobody listens to him. That way it's very good. What I am saying is, Gandhi wrote a very good letter which has been published in Harijan magazine. It said that Panditji has been misunderstood. Khadi will continue as long as India lives. He wrote a letter. I asked the managing director of Airport Authority, have you read this letter? What is the crime she has committed? She has to be congratulated for following a fundamental duty. And therefore, suddenly I remembered Justice Krishna here, after retirement, whenever he goes, he'll wear a khadi shirt, khadi dhoti and a rubber slipper. Mamata Banerjee slipper, they say. And then he went to the Madras Cricket Club. Madras Cricket Club, more English than India. So the Darwan said you can't allow inside because you are not wearing a proper dress code not followed. One lawyer invited him. He got angry. He told the Darwan that This man is a retired Supreme Court judge, great jurist. That one said, my rule book only allows only this dress, not any other dress. And it became a very ugly scene. And Krishna Iyer said, he didn't want to have this ugliness. Bring that visitor's book. In that visitor's book, you can even today see, he made a very beautiful endorsement. In this Englishman club, Indians are not allowed. True Indians are not allowed. I am going out as a proud Indian, though I denied my supper tonight. Krishna Iyer. I quoted this letter, this endorsement in my judgment. I said that a public sector in this country do not understand the ideals with which the Indian freedom was fought, the steadfastness by which that lady want to maintain her resolve to wear only khadi. Instead of appreciating, you have punished her by suspending her. Is there a case for suspension? I quashed that suspension order. I didn't leave with that. I also said that the managing director shall pay 5,000 rupees cost to this woman for causing such harassment. During this judgment, I also do some Krishna Iyer, we have Krishna Iyer's followers. Krishna Iyer always coins new words. So I said, this is nothing but a sartorial despotism. So we have in our country sartorial despotism, which you see in Karnataka, by which 20,000 girls were unable to write 10th standard examination. On whose basis? What is the basis? Somebody says they must wear a uniform. They were wearing a uniform. They were covering their head. Does your uniform say nobody should cover their head? Now the fundamental question is, in 1999, when they wrote 21A into the Constitution, all children, whether girl or a boy, up to the age of 14, will be compulsorily educated freely in this country. It's a fundamental right of this country. So if a person comes, you must educate. Only ask question, are you up to 14 or not? There is an act, 2009 Act, Right to Education Act, which says no children can be detained, no corporal punishment. Then when you talk about discipline, how do you explain all this? How many teachers are saying, why I can't give him some lesson? Why I can't put him as a little beating? In our school days, we were beaten up by our teachers. Today, that's not possible. No detention, no beating, no corporal punishment. All that is agreeable. All that part of discipline. Wearing a headscarf become indiscipline. Where is the constitutional mandate? That is what I am saying. In the name of hijab, denial of hijab, in the name of discipline, you are preventing thousands of children coming to the school. Now this is nothing but a sartorial despotism. This is what our constitution should prevent. No other question can be asked. There was a Chief Justice who said, no, we will hear 3 judges bench. How long? To decide this matter, only half an hour it will take. It doesn't take 10 days, 2 weeks. Finally you say, we are not interfering. Interfering is what? It is the education department which is dictated by the Nagpur Walas, which is doing all this. Now interference means interfering in favor of the people who are coming to learn in this country, who are coming to exercise their right of compulsory free education. In my school days, I can tell you, we were all in school. There are many children will come without upper cloth, straight from their house. No teacher ever sent them out, go and wear a shirt and come. No, because it was an inclusive society. The teachers wanted them to come to the school. They were canvassing from every house, please send the children to the school. We want them. There are many boys with their trousers with a lot of holes, never stitched because they can never afford. It was the inclusiveness which brought the children to the school. It was because of the inclusiveness we got Article 21A. But then there are some people in Karnataka who are now experimenting here how to exclude people, how to throw out people from the system. It's the same doctrine, majority doctrine. You decide what is good for others. The others can't decide for themselves what they should eat. Whether it is a hijab or a halal or azam, you decide. You sitting here in Vidhan Sauda, you decide. Who gave you that power? Karnataka has become a real experimental lab for all this hate politics. We should not be succumb to this pressure. Though I'm talking about gender justice, it is not, times are not far off. This can spread to every area. Need not stop only with women. It can go anywhere. Now they say, no, we are doing this, we are doing that. Now Supreme Court says we have no time to hear this case. Which case you will be hearing? Nobody knows. We are busy lecturing all over about India's greatness, how the system has become so vibrant, Indian constitution is so dynamic. All this for foreign years. What about local? We have an alternative dispute resolution. Go there, go here. Like a traffic policeman, you send people elsewhere. Now this is what most important today. When we talk about gender issue, it can't be divorced from other issues in this country. If there is going to be a gender justice, it is also linked with a common man problem. It is linked with the labor, it is linked with the agriculture, it is linked with every issue in this country. It is linked with social issues, political issues, economic issues, and it deals with political power. And therefore, it is not as if Constitution is silent. It is writ large in the Constitution, the right of women. No other constitution in the world talks about women in more than half a dozen articles. Article 14, 15, 16, then you have 43, 44, then 45, then you have 51AH. You have so many, 37. You have so many, 39D. There are so many articles deals with gender issues. Now, what is lacking today is a proper orientation for the judges. That is most important, because when you sit in the chair, when you take the oath of office of a High Court judge or a Supreme Court judge, you take a oath that you will uphold the Constitution. And Constitution must be upheld without fear or favor, without ill will. And then what happens is the opposite. Now that is most important, whether it's a religious issue or a political issue or an issue of employment. Everywhere the gender is a gender discrimination. And now the last question, what about orientation of the women? I told you in Ayyappan judgment, the lonely dissenter was a women judge. In Pinnayakal case, the wrong order is passed by a women Tahsildar. It's not just being a woman, it's something more. We need to educate. We need to have a proper orientation. Somebody asked me, by increasing number of women, is it going to change the situation? Definitely it will change. Quantitative change will bring a qualitative change. But nevertheless, there must be a orientation. Now that is most important thing that we must understand, that this book, if it is going to help in such a way, that it gives a new orientation to law students, lawyers, judges, judiciary, or for activist women, I will be happy that Nannaduru Keli has reached the real hands. Thank you.